So just roughly what we're going to cover this morning in the flexible working session. So I think the word flexible working is quite a buzzword and it's used, to describe a lot of different things. So it can be things like if you maybe have a policy in your office where you say, you can come in. Some days you can work from home, some days, and you've got a bit of flexibility. Some people even have like a hybrid and home working policy. But today, when I'm speaking about flexible working, we only have really 25 minutes in the session. So I thought I'll focus just on the statutory flexible working request. So I'm not really thinking about, that overarching or more general flexible working. It's just that statutory request that people can make because that's what's going to be subject to change this year. So we'll go through the legal framework that makes up a statutory flexible working request and gives it that statutory effect. Then, rather than take you through the scheme that's going to, no longer be in effect as of April, we'll focus on what's actually changing to the scheme, and what that's going to look like and what you'll need to incorporate into your policies. And then to finish off, we'll just more so run through a very brief because of the time that we have, but we'll run through, how would you deal with a request, a bit more about the process, and I think we'll just finish on that and hopefully have time for some questions. So the legal framework is obviously a statutory flexible working request, which means, the reason that people have the right to make this is because there's a legal statute that gives them that right. So you can find, if you want to go and look at the bare bones of what the legal right is, you can find that in section 80F of the Employment Rights Act. I think that sets out different things like, I think it's worded like that they can vary their contract in relation to their hours, the days they work, and also the place they work. But when it's talking about varying their contract, that's really asking about changing the terms in relation to those things. So it's a flexible working request. And obviously, with that being legislation, if you're looking for a bit more user-friendly language that, sets out what the law is, ACAS have got a code of practice and flexible working request, similar to the discipline and grievance one, in that it's not just, ACAS issued guidance, it's actually a statutory code of practice, which means, it's got statutory teeth. The code is law and that you'd be expected to practice according to it. That comes into effect with tribunals as well. If you're deemed not to have followed the ACAS code of practice and flexible working request, that would constitute you falling short of your legal requirements. And as I say, the law on flexible working request is changing. So right now, I think there's a draft code of what that's going to look like when the legal changes come into force. So there will be an updated ACAS code coming out this year. I checked to see if we have a date for that, of when to expect it, but I think everything is just very much coming soon in 2024 at the minute. So I'll look out for that, and we'll probably put out to members when that's out. So now looking at the updates to flexible working requests, and as I said at the start, just for anyone who never caught it, rather than saying what the kind of key features are just now when they're going to be changing in April, I thought I'll outline what the changes are going to be and make reference to what they are just now instead. So the first kind of update that's coming in as part of the new flexible working update is going to be that there's no requirement for the employee when they're making their statutory request to flexibly work to spell out how this is going to impact their employer and how they think their employer could deal with that impact. So I think right now, if they're like putting in the request, they really should be saying, so for example, I no longer want to work Fridays, I want to work all my hours, the same amount of hours over Monday to Thursday. Imagine that you might be a bit short on the Friday. I think you could deal with this by, introducing overtime for that. It could just be something like that, and it's really just the employee's interpretation of what they think the issues might be and then how they think you could deal with the issue. But as of April the 6th, they're no longer going to have to do that. So all they have to do is make the request, and it's up to the employer to do that assessment of how's it going to impact them when they're determining it. Next one is that it's going to be a day one right. So at the minute, someone has to have 26 weeks continuous service and employment to make a flexible working request. But as of April, someone could essentially come in, you know, start employment with you, go through your onboarding process, and then the next day they could put in a flexible working request to, change their hours or request home working. So that, it's now going to be open to employees who are new starts as well. The next one is that you might be aware that at the minute you can only make one statutory flexible working request in any 12-month period. So I think the way the law requires that is that the employee should actually say on the request, I've never made a flexible working request, or I made one in October 2023. And that's so that you can, make an assessment quite quickly on whether or not they're eligible to make another one. So at the moment, it's one in any 12 month, but as of April, they're going to be able to make two in a 12-month period. So it's worth having that in mind. The next one is that you must make the decision within 2 months of receiving that initial flexible working request from the employee. So the whole process and the outcome should be delivered within 2 months. It's currently 3 months. And what I will say about that is sometimes these can be quite complex. You might have to look at other roles or go through a bit of consultation, finding something that's suitable. If it's going to take over 2 months, or if it's going to take over 3 months, and when you're doing just now, you can extend that, but it needs to be extended in agreement with the employee. So if you're taking longer than 2 or 3 months, which is the legal minimum, um, you really should be writing to them, letting them know why, and issuing an extension, and I would have them sign that as well, or just confirm their agreement to that extension. And the next change that's coming into force in April 2024 is that if you're rejecting it, based on one of we'll talk about that later, but you've got 8 statutory business grounds that you can reject a request. But if you are rejecting their initial statutory flexible working request, then you're now going to have a positive obligation to consult with the employee on alternative arrangements. So, if you're unable to grant what they've asked for in their initial request, but maybe you can work with them. So maybe say they want that Friday off to do the compressed hours, using the example I gave earlier. Maybe that's just a bit of a stretch. Could you maybe do a 9-day fortnight and have every second Friday? Or maybe you can offer reduced hours on a Friday, but not the complete day off. Always link back to the business reasons. So you're now going to have to do a bit of consultation if you plan to reject. So that kind of covers the changes that are due to come into force in April 2024. I don't think it's too onerous. I don't think it's anything, really new and different. I think that the last one's probably the first and the last, probably the ones that are new. The rest is just really extending things that are already in the statutory scheme. So I just wanted now that we've covered off, what's going to be different, just have a quick look at the scheme itself, how you would deal with a request, what that might look like, just as a recap, since we're going to be having to make updates to this scheme and your policy if you have one in place. So I've just listed this from ACAS. This is their list of, the types of things that people could request. Because I think the statute does just read quite limited. I think it says, you have the right to vary your contract, to make a request, to vary your contractual terms related to hours, place of work, and the days that you work. But really, this could take form in a number of ways. And this is ACAS's list. So I think there's some obvious ones like change your start and finish time, reduce, maybe if you're closer to full-time hours, reducing that to part-time. But it's not just the hours and the days that you work, it's also where you work from. So if is mandated to be in all the time. If they're able to carry a bit of their role out at home, and maybe they want to make that a permanent change to their contract, that they're able to work home every Monday, Friday, can do it through this as well. And also things like compressed hours, flexi time, I think it's most commonly known as, but you know, if you've got a core hours and they can alter their start and finish time as long as they do the work in that time, these would all be classed as arrangements that you could request through one of these statutory requests. And I've just put at the bottom there, no reason required, because I think that's quite an interesting thing. Um, you know, I think I've spoke to people before and they've had one of these requests and they could say things like, but it's because they've got a gym class on a Friday, or, you know, they meet their friend for lunch. You don't actually have to give a reason of why you need that change made. You know, in essence, anyone has the same right to make a flexible working request, whether that's because you have a Pilates class, whether it's because childcare, you would have to do the request the same no matter what the reason behind it is. And while they might give you a bit of background as part of the request to make it easier to go through and give you a bit more information, they don't actually have to give you a reason of why they want the new arrangement. So just looking at the process from, you know, when they put the request in, to how you deal with it, and then and the outcome that you'll give. It's a short session today, so will be quite a run through of it. But I've had a look at, you know, what are the musts that you have to do, what's the legal position, looking back at that ACAS code I discussed. And you know, the first thing it says there is that the request that they put in must be in writing. So if they want it to be dealt with as a statutory request, it should be in writing. And then they set out a few things that should be included on that request in writing. So it must have the date of application. And I think that's just so it's really easy for the employer to keep within that 3 month, soon to be 2 month time scale from the start to delivering the outcome if it's dated. The next, they should clearly say what the changes they're seeking. So, you know, it's not very helpful, and it wouldn't be in line with the requirements of the statutory scheme if they just said, you know, my hours are a bit Um, my hours are a bit intense at the minute. I'm looking for something um, a bit less onerous, less hours. I think I would want more explicitly of, you know, what the arrangement they're looking for is, to go back to them and ask that to clarify. And next, they should say when they want it to come into effect. So, you know, I would really like this change to come in August 2024, because that's when, you know, the schools go back, and I'll be struggling. So they should set all these out at the outset of their request. And the next, it actually says that they should clearly state that the request is made under the statutory scheme. And they should also say if they've made a request previously. And that will just be because you can only make soon to be two requests in a 12-month period. So, you know, if they say, I've made statutory schemes 3 times in the last 6 months, um, you wouldn't actually be able to deal with that last request as a statutory one, subject to the same checks when you're doing your outcome. And just on that point as well, when it says that they should clearly state it's a request under the statutory scheme, sometimes, you know, not all employees are going to know that they have this statutory right available to them. So I think I would probably say, yeah, if it looks like a statutory flexible request, I would be inclined to deal with it as one, or to clarify with them. And at least when you're making any sort of decision on it, be referring to the 8 business reasons that we're going to go on to look at later, just to be safe on that. When you've received that request and you're happy it's all in the correct format and that you've got enough to consider, then you would be scheduling a meeting with the right to be accompanied. So that's just similar to a disciplinary grievance, whereby they can bring a trade union official or another colleague. And that's really just to discuss the request, get a bit more information. You know, if you have any questions, you can ask it then. What I will say is that if you get a request in and you're just completely happy with it, so maybe someone's asking, they have it formally work from home on a Friday, but you already have a pretty flexible approach and you can't imagine there'll be any issues with it and you're happy just to grant it straight away, then you wouldn't need to have that meeting. You could just give them an outcome and grant that if you're happy with the request. But if you're not so sure about it, you need a bit more information and that you're not happy just to accept it at the outset, then a meeting should always be scheduled. After the meeting, you might find that you have some inquiries to make to see if it's feasible. Maybe you need to link in with the leader of that team or that shift. You just need a bit more information. So you might have to go away and do that after the flexible working meeting. But eventually you want to get to the point where you've considered the request and you're ready to give an outcome. And I would always say, it's best to give that outcome in writing. I think if you just have the meeting and then give them it verbally. You really want to take away everything they've said in the meeting and have a good think about it against the business reasons. And similarly, if you've got an internal policy, I would always check that because they'll normally say things like after 5 working days of the meeting, give you an outcome. So if you've bound yourself to any sort of internal policy timescales, you'd want to be aware of them just so that you're not falling short of your policy. So I'd have a look there as well. So when you've got to that point, as discussed, where you're ready to give an outcome to the request, there's kind of different ways you can do that. So quite often, one thing that I hear is, I think it will be okay, but can't be sure at the moment. Would really need to see how it happened, and you can be quite nervous about granting that as a permanent change to the terms and conditions. And then 3 months down the line, you realise that your suspicions were true, and it's going to actually be really difficult. So quite often people will grant it, but as a trial period. So for example, in that outcome letter, it might say something like, we're willing to accept it subject to a 6-month trial period. We'll check in and review every 2 months during that trial period. And at the end of it, we'll give you a decision on whether or not we're willing to make this a permanent change to your terms and your terms and conditions, and just making it clear that if it doesn't work out, you've got the right to move back to what their working hours or their working situation was before they put the request in. So just reserving that right, but giving them a chance to try what they've asked for and see if it works for you, for the business. And the next one is that if it's granted, it would normally be a permanent change to terms and conditions, unless you've stated otherwise. So I'm just getting some background noise through. That's it. So unless you've stated otherwise, accepting that flexible working request will be a permanent change to their terms and conditions. So, if they've asked to change their start and finish times and you accept it, that would be a change to their terms and conditions, and that would now make up their contract. And as I've spoken about the 8 business grounds that you can reject a request on throughout, and I've just stated them down below. So you'll see it's all things that are related to the business. So it's not a case of just rejecting one because the person who's made the request often sits on their desk at their phone and you couldn't trust them to be at home. It needs to be related to one of these reasons, and it can't go out with the scope of them. So it's things like the burden of additional cost, detrimental effect and ability to meet customer demand. You can't reorganise the work among the existing staff. So if they're leaving a specific team, you've assessed that and you don't think that the work they're doing could go with who's there. It's too much. Inability to recruit additional staff, detrimental impact on performance, insufficiency of work during the periods the employee proposes to work. So for example, if they're on, one shift and there's loads for them to do, they're asking to change shift somewhere where, there's just no where they want to go, there's not enough work for them to do. that would relate to that situation, and I've heard of that one coming up a lot. And planned structural changes, so that might be they're asking to go on a shift, to change shift, maybe their night shift, they want to go on to a specific day shift with certain hours. But when you've looked at that, you know that that shift is planned to change soon, and it wouldn't be suitable for them in terms of the request. So because you've planned to change that structure, um, you could potentially reject on those grounds. So what I will say with these is sometimes I'll maybe review an working outcome request, or I'll see these letters later down the line, um, for part of a tribunal, things like that. And someone might just say on it, I'm rejecting your request because of the burden of additional costs. And then it will just end there. But I would really say that your outcome should be setting out everything you've thought about, um, inquiries you've made, really giving a round of the process you've followed and explaining why there's the burden of additional costs, or, explaining why their request wouldn't allow you to meet customer demand. So I think it wouldn't be enough and to just say use it as a label. You really want to be giving them a good reason, rationale, and linking it to the reason rather than just stating it. So I've just put down, just to finish us off, just some kind of next steps, given that as of the 6th of April, we're going to have some changes. So what I think you could likely be doing now just to get ahead of that. So the first one is just to familiarise yourself with your internal policy if you have one in place, just so you really know what it says, ahead of changing it. 6th of April is the date that we've got just now to make the changes. So really you want to have the changes made by then to issue it to people. You could make the changes early, if you want to be more generous than the statutory scheme, from now to April, if you want to get ahead, but don't have legal effect until the 6th of April. When you've made that, I would communicate there's been an update, so if it's in a handbook or anything like that, just make sure that people know that it's now changed. Anyone who might use the policy, who's conducting these meetings, assessing requests when they come in. I think this has been quite widespread reported. Most people I speak to at least know there's a change coming up, but it would be good to, just train your HR staff or anyone who uses the policy on what the changes are, just so they're not getting a request in and automatically rejecting it if they've already done one in the past 12 months. They should know that it's two now, things like that. Just these kind of intricacies, make sure that they're aware of them. The next one, I would just have a think about your current practices in light of the anticipated changes. When I was thinking about this one, it was particularly about timescales. So they're changing it to 2 months. It's currently 3, but I know just from speaking to people that sometimes these can end up a bit more complex and they can take people a while to process and go through, especially if you might need more than one meeting if you're going through different options. So if you're taking maybe like 4 months to do one of these requests, it's worth having a think about the fact it's going to be too soon, and remembering that you can extend the time scale. So I think that kind of rounds us off with what I planned to speak about. But when we're just thinking about kind of why this is important, I suppose, flexible working, it's less common to be a standalone claim, but it can be. I think quite often I see flexible working requests, if they're not dealt with properly, creeping up in discrimination complaints, particularly. Someone feels that their request's not being dealt with, in the context of, other discriminatory allegations. See a lot in those kind of cases. Also see it crop up in grievances a lot. So, it might just be kind of open the floodgates for more and more internal grievances if they're not being dealt with properly. And then there's always a kind of risk there of some sort of constructive unfair dismissal claim if someone's request is just, taking months and months and they're not getting anywhere with it. That might lead someone to, resign from their role and claim constructive dismissal, just because they believe that that treatment of the request has been a breach of their contract. So it's worth just thinking in the background of how these flexible working requests can cause issues later down the line if they're not dealt with properly. So I think that finishes us off. I've left us a grand total of 3 minutes for questions, so I'm happy to take any questions before I go off. If anyone needs to pop off now, you can email me any questions you might have afterwards.